The legal profession is anchored in text and historical precedent. Every argument relies on the physical record of past decisions. Modern lawyers often assume that digital databases like LexisNexis and Westlaw simply digitized the physical library to make finding those past decisions faster. Medium theory challenges that assumption. This field of study posits that the medium used to communicate information dictates how the human brain processes it. Moving from physical books to electronic keyword searches dismantled the shared, homogenizing taxonomy of the common law. The digital search bar functions as an epistemological engine, subconsciously dictating the scope of arguments a lawyer can construct. Historically, legal decisions were published chronologically, not by subject. Navigating this physical mass of unindexed case law to find a relevant precedent was practically impossible. The architectural solution was the West Digest system. This system categorized every case using a massive, standardized index of specific topics, assigning each a unique key number. For over a century, generations of law students and attorneys were trained to conceptualize every legal problem exclusively through this specific, rigid hierarchy of topics. This framework established a virtual conceptual tyranny. A lawyer could not invent a bespoke legal theory. They had to force their clients' facts into the predetermined labels recognized by the digest. The physical architecture of print research functioned as a homogenizing bottleneck, ensuring all opposing lawyers built their arguments from the exact same conceptual starting line. To understand how this bottleneck worked, look at a paradigmatic print search. A researcher begins by selecting a specific jurisdictional case digest. They match their legal problem to a recognized key number. Before reading a single word, the researcher sees specific contextual information, the subject category, legal principle, and a summary blurb. Physically locating and reading the actual reporter volume is a massive, high-friction task. This high-friction penalty acts as a filter. It forces researchers to be highly discerning, actively discouraging them from pursuing marginal or tangential legal theories. Consequently, print researchers encounter and interpret every individual case strictly through the pre-approved, context-heavy lens of the digest's key system information. Cognitive psychology explains why this system commanded such authority. A core principle of the field shows that affixing a label or category to an item significantly alters human perception of that item. The 1963 Toshfell and Wilkes study presented 8 vertical lines of varying lengths, without labels. Adding label A beneath the shorter lines and B beneath the longer lines shifted perception. Labels cause the brain to exaggerate differences between categories, while artificially minimizing differences within them. This psychological data maps directly onto the West Digest system's key numbers. When a lawyer reads a case under a specific digest label, their brain subconsciously minimizes the case's unique nuances. The psychology of categorization forces the text to conform to the established doctrinal category. The transition to the electronic workflow replaced that rigid digest structure with a blank input field. Electronic searching emancipates the lawyer from the digest entirely. They can now invent highly individualized, bespoke search criteria. This eliminates the friction of print research. An electronic search strips away the contextual label and drops the reader directly into a highlighted snippet of text. Ultimately, this interface design triggers confirmatory bias. It is the human tendency to seek out and emphasize information that supports a pre-existing hypothesis, while ignoring contradictory data. With a near-zero time and energy penalty for clicking false leads online, lawyers hunt exclusively for data supporting their initial theory. Search algorithms pull anomalous, context-free case texts simply because they contain the exact linguistic matches a lawyer typed into the search bar. The electronic database functions as a confirmation bias machine. It rewards lawyers for isolating text from its doctrinal context to support bespoke, highly individualized theories. This cognitive fracturing creates 2 systemic consequences for the legal profession. The first is diversity in framing. Diversity in framing occurs when opposing lawyers, no longer constrained by a shared vocabulary, present wildly divergent legal theories to conceptualize the exact same set of facts. The second consequence is tilting at windmills. Tilting at windmills is the increasing advancement of marginal, outlier, or historically anomalous cases that would have been buried or ignored in a print digest. Together, these two phenomena cause the structural breakdown of common law precedent. The adversarial system is now flooded with these outlier arguments, forcing courts to process a radically wider spectrum of legal thought. Modern legal unpredictability is frequently driven by cognitive behaviors triggered by our search interfaces. This burden ultimately falls on the judges, who must resolve these fractured arguments. In an adversarial system, judicial options are strictly defined by the theories proffered by counsel. The surge in diversity in framing inadvertently expands judicial authority by providing judges with a wider, more fractured menu of options for dispute resolution. Meanwhile, the unearthing of unpublished or marginal cases via keyword search forces the continuous stretching of established doctrinal boundaries. The content of the law shifts beneath our feet, driven by the architecture of the databases we use every day. This electronic ecosystem rewrites the boundaries of thinkable legal thought, manufacturing the law through the very tools used to find it.